Jai Jagannath. Welcome all to my today's class on entrepreneurship and startups. Today's chapter is intellectual property rights. So let's start. Introduction. What is intellectual property? That is definition of intellectual property. Intellectual property refers to creation of mind. It is a creation of mind. Like creation of mind means what? Mind, something created by my mind. That is, it may be a invention, it may be a artwork, it may be a literary work. Literary work means some literature, some design, some specific symbol which is created by me. This symbol should not exist with any others written documents. So I can tell that these are my intellectual properties. So intellectual properties broadly categorized into two parts: copyrights and related rights, industrial property rights. Copyrights and related rights, and industrial property rights. The copyrights and related rights means that is, copyright is there for books, music, for softwares, for artworks. For that we can create copyrights or any type of related rights. But for industrial property, how I can tell that it is my intellectual property? By making patents for that, by making trademarks, by making industrial design registered, like Coca-Cola's brand name. I cannot claim that Coca-Cola is a brand created by mind now, because it is already with Coca-Cola company. So that is a industrial property rights. Then we'll see importance of intellectual property in art, literature, science, trade, etc. Art. Intellectual property protects creative works like paintings, music, and films, what I have already explained. It ensures artists are credited and compensated. For a musician, his rights to sing a particular song and earn royalties for that song is a intellectual property right for him. This is called importance of IP in art. Then in literature, author use copyrights to control how their books or articles are used. They help them earn from their work. Think of a novelist license their book for a movie. A novelist suppose a license a book for a particular movie. Then how it is linked with science. Patent protects scientific inventions and discoveries. Like you know that for yoga, our India has the patent. This encourages innovation by giving inventors exclusive rights. For instance, a new drug formula can be patented. A new drug formula can be patented by that particular person who has invented that formula. Then for trade, trademarks and trade secrets protect brand identity and business strategies. This builds trust and competitive advantage. Like I have already explained an example of Coca-Cola logo and its secret recipe. Then role of IP in protecting creators' interest. IP gives creators legal rights over their work. Who created that right? Who created that IP? It gives rights to that person for preventing unauthorized use of the creations made by him. It ensures they can earn recognition and financial rewards. For example, a filmmaker owns the right to their movie and can control its distribution. Suppose I want to reproduce a Sholay movie today, so I have to take permission from the producer of Sholay, original Sholay movie, for giving rights to me, and I have to pay royalty to him because the rights of Sole movie is with that producer only. I can't produce with the same story and same name today without his permission. That is called protect creators interest. So this is role of IP in protecting creators interest. Then TRIPS agreement. The TRIPS agreement 1995 under WTO sets minimum standards for IP protections globally. TRIPS agreements in 1995 it was made, and it sets minimum standards. What are those standards? If you see in the study material, it is there. Copyrights and related rights, trademarks including service marks, geographical indications including appellations of origin, industrial designs, patent including protection of new varieties of plants, the layout designs of integrated circuits, the undisclosed information including trade secrets and test data. So this is what about the introduction part of this intellectual property right. Now we will get into some details. Types of IPRs. What are the types of IPRs? For I have already told now, IPR intellectual property rights includes copyrights and related rights. So this is copyright is one of the type. Copyrights protects what? Literally artistic and musical works that I have already told. Then comes trademarks. Protect brand identity. For example, Nike, Coca-Cola. This the trademark of their is creating their own identity for that company. I cannot use the trademark of Nike and Coca-Cola for my company. Geographical indications. Identify products from specific regions. For example, Darjeeling tea. Darjeeling tea is one of IPR which which gives rights to that company that I cannot claim Darjeeling tea for my tea products. Then industrial designs. Protect the aesthetic aspect of products. For example, design of a luxury watch like Titan. Titan so design cannot be copied by any other local companies or any other companies because it has rights. Titan has the right for that design. Layout designs of integrated circuits. Protect chip designs. Then trade secrets. Protect confidential business information. For example, Coca-Cola's recipe. Utility models like patent, but for minor innovations useful for MSMEs. Utility model means patent जैसा like patent, it is equivalent to patent, but this is used mainly. This term is for MSMEs, small companies. They don't use the word patent. They use utility models, minor innovations. Now we'll see different IPR laws in India. If you see the timeline, first in 1957 Copyright Act was passed. It covers literary, musical and artistic works. Then in 1970 Patent Act was passed that grants 20-year protection for inventions. Then in 1999 Trademarks Act, which covers brand names, logos, etc. It is not there in copyright and patent. It comes under Trademark Act. Then comes Design Act 2000, protects product designs. I cannot copy a design of another company's product. I cannot copy the design of Maruti's car for manufacturing my own car. Maruti can claim copyrights for that. This is part of industrial design, that is under IPR laws. Then GI Act, Geographical Indication of Goods Act. It is made in 1999. It protects regional product identities. Okay, that is Darjeeling tea, I have already told. Then comes in 2000 Semiconductor Integrated Circuit Layout Design Act. Then in 2001 Protection of Plant Varieties and Farmers Rights Act. Then in 2002 Biological Diversity Act. So these are the different IPR laws which helps support this intellectual property rights. As an entrepreneur, we should know about all these laws. Otherwise, I cannot able to protect my rights. I have to know. Then comes, what are the benefits? I think I have already explained, but still we will cover this slide. First is protect innovative products and services. Suppose I have made a innovative product out of my own invention, out of my own innovative mind, so I can keep that products, that invention with me. This idea cannot be repeated or copied by any others because of this IPR. Next, increase visibility and value of products. The product's value will definitely going to increase because of this, because that product is available with that person who has created that. So definitely the value will be like that. Okay. Next, distinguish business from competition. Because of this, we can bear competition. We can bear, because that product is only of me, not of others. So I have the right to produce. Nobody can have the right to produce. If I give right to produce to any of the company, then that company has to give royalty to me for that idea. Next, access technical and business information. Then avoid risk of using third party component. Then encourage innovation. Because of this type of laws, this type of IPR benefits, a person is encouraged to innovate again something new to create its own identity. Then establish brand awareness and trust. Obviously, a particular new brand is created every time, and trust of that brand is also created with the public. Then common mistakes by entrepreneurs in IPR. What are those mistakes? First mistake is this neglecting IP, that is not considering IP as important. Always neglect, because I don't today you are learning this paper, so you have some knowledge about IPR, but generally people who start the businesses in India, they don't know about this IPR laws or IPR. What is IPR? They don't know. So because of that, many of startups don't prioritize IP early, so that because of this, their idea is again copied by others, and they use the benefit of this IP. Next is insufficient research. Not checking for existing IP can lead to infringement. That means before going for your own rights about the idea, please check please check in the market that whether the same idea exists or not. If exists, whether somebody has already applied for IPR or claimed IPR or not. You have to check all these things. Next is ignoring trademarks or trade names. Means trademark oversight. I am telling you. Using unregistered or already registered names. Already a particular name is there and I am copying that name. This is also a common mistake made by an entrepreneur. Then lack of proper agreements, that is no agreements, failing to secure IP ownership from employees or partners. If your IP is, if you do not have proper agreement with your partners or employees regarding your IP ownership, so then anybody can use that IP. So you have to make proper agreements. Then failure to protect ideas legally, no legal protection, not filing for patents or copyrights. Generally these mistakes are done by entrepreneur. A startup launched a product with a name already trademarked by another company and had to rebrand, losing market momentum because of this mistakes he has done. Already a particular product is there in the market which is trademarked by another company and I have lost. So obviously he will claim that copyrights and you have to lose everything. You have to lose everything. You have to lose your capital, you have to lose your market, you have to lose your brand name, everything you will lose. So we should know all these things. Now we'll see different government schemes for MSMEs and startups. 50% fee concession for MSMEs on patent filing fees. Government has given this benefit to the MSMEs. That is 50% fee concession on patent filings. If they are filing for patents, they are given 50% subsidy on that, or fee concession, not subsidy, 50% fee concession, आधा पैसा देना. Then for the startups, Startup Intellectual Property Protection Scheme, SIPP scheme was there, which gives 80% rebate on patent fees for the startups. Then facilitators help with filing and prosecutions. Then also 10,000 rupees reimbursement for facilitator services. Then expedited examination under the Stand Up India initiative. स्टार्टअप्स के लिए ये सब चीज़ एप्लीकेबल है. यहाँ पर मैंने लिखा नहीं है इतना सारा चीज़, स्टडी मटेरियल में है, बट SIPP स्कीम में आपको 80% रिबेट मिलेगा पेटेंट फीस पे. देन फैसिलिटेटर मिलेंगे आपको हेल्प करने के लिए कैसे फाइलिंग करना है एप्लीकेशन, कैसे आगे बढ़ना है. देन फैसिलिटेटर सर्विसेज के ऊपर में 10,000 तक आपको रियम्बर्समेंट मिलेंगे. फैसिलिटेटर तो फ्री में सर्विस नहीं देगा, फैसिलिटेटर जो पैसा लेगा उसमें 10,000 तक का आपको गवर्नमेंट से रियम्बर्समेंट भी मिलेगा. ठीक है. उसके बाद एक्सपेडिटेड एग्जामिनेशन फॉर स्टार्टअप्स अंडर स्टैंड अप इंडिया इनिशिएटिव. स्टैंड अप इंडिया इनिशिएटिव के हिसाब से भी आपका एग्जामिनेशन बहुत जल्दी होगा, प्रोसेस फटाफट होगा. ठीक है. तो ये था IPRs का चैप्टर. So we'll see in the next video for the other chapters. Thank you. Jai Jagannath.